In Vehicle Code Section 14601, California law makes it a crime to drive when your license is suspended. Now, this is different from a situation where you've never had a license or your license has expired. Then you would be charged with a separate crime of driving without a license. But the law treats it even more seriously when your license is suspended than when you don't have one. And the idea is that the DMV has specifically told you cannot drive for certain reasons, yet you go ahead and do it anyway.
In California, the law does not allow a person to be convicted for driving on a suspended license if they did not know of the suspension. In fact, people oftentimes drive on a suspended license without knowing it, either because they never received notice of a license suspension or because they mistakenly thought that their license had been reinstated.
In a driving with a suspended license case in California, there are generally two ways the prosecution will try and prove that you had knowledge that your driver's license was suspended. The first way is they want to show that you were either mailed proof of your suspension or revocation, you were served by an officer with a notice of suspension or a notice of revocation, or if you appeared in court and a judge specifically advised while you were in court that your license is suspended or revoked. In these three circumstances, it will be presumed that you had knowledge that your license was suspended or revoked.
If you're convicted of driving on a suspended license, Vehicle Code Section 14601, you can face probation, fines, and potentially up to 6 months in jail. Now, oftentimes there's no jail imposed. However, there's one exception, and that is if your license was suspended because of a DUI and you're caught driving on a suspended license, in that case, there's a minimum 10 days of jail that the judge must impose, and potentially up to 6 months. Moreover, anytime you're arrested for driving on a suspended license, your car will almost always be impounded and many times held for 30 days.
Simply put, this is a charge where a lot of innocent people get wrongly accused. Fortunately, here at the Schaus Law Group, we have a great record of success on getting these charges either reduced or dismissed.
One of the most common defenses to a driving with a suspended license charge is that you did not know that your license was suspended. Now, maybe you didn't receive the notice in the mail, or it was sent to an old address, or maybe you weren't actually advised by an officer or a judge that your license was suspended. In these cases, you can assert the defense of lack of knowledge to prevent you from being convicted of driving with a suspended license.
Another common defense in a driving on a suspended license case is that the suspension itself was invalid. So, for example, maybe the DMV had suspended your license for failing to pay a traffic ticket, when in reality you really did pay it. Or maybe your suspension was supposed to have elapsed and your license renewed, but the DMV had a clerical error and never actually renewed it. If we can show that the underlying suspension was invalid, we can almost always get this charge dismissed.
Another way that we defend the charge of driving on a suspended license is by establishing that the officer did not have probable cause to stop you in the first place. In which case, we can bring what we call a suppression motion in court to exclude any evidence that flowed from the stop. If the judge grants our motion, the charges are usually dismissed.